They didn't read me my rights. This is one of the most common things that I hear from DWI clients on a regular basis. The thing is, with most DWIs, this really isn't a big deal because many times in these situations, Miranda doesn't apply. So let's talk about Miranda warnings and when they're required. Miranda versus Arizona was a landmark case for criminal procedure decided by the United States Supreme Court in 1966. The court interpreted the Fifth Amendment's provision that no person shall be compelled to be a witness against himself, means that a person shall not be compelled to give self-incriminating testimony. Therefore, when a person is subjected to custodial interrogation, the police are required to advise the arrestee of four things. Number one, he has the right to remain silent.
You have the right to remain silent.
Number two, anything he says can be used against him in court.
Anything you say can will be used against you in a court of law.
Number three, he has the right to the presence of an attorney.
You have the right to an attorney.
And number four, if he cannot afford an attorney, one will be appointed for him if he so desires.
Provide you with the dumbest lawyer on earth.
So the question is, what constitutes custodial interrogation? Well, custodial generally refers to the time after which a person has been placed under arrest and is therefore in the custody of the police. The Supreme Court has also developed a two-step process to determine if someone is in custody. First, whether a reasonable person under the circumstances would feel that he was free to leave or terminate the investigation. Second, whether the relevant environment presents the same inherently coercive pressures as a traditional police investigation. Because a person who is placed under arrest obviously can't terminate the investigation and leave, questions of whether a person is in custody tend to arise prior to the arrest. The most common situation where this occurs is during the traffic stop. Traffic stops are generally not custodial, even though you're not free to leave. The Supreme Court's held that because the stop is presumptively temporary and the motorist knows that he will soon be on his way, Miranda warnings are generally not required. For example, the Supreme Court's held that questions asked by police during administration of field sobriety tests do not require Miranda warnings. Interrogation generally refers to official questioning of a detained person by police. More specifically, it refers not only to express questioning, but to any words or actions on the part of the police that the police should know are reasonably likely to elicit an incriminating response. That means that routine questions involving your name, date of birth, address, etc. do not require Miranda warnings, but questions like, "Why did you kill him?" do. This also means that you have to be attentive to any casual conversations that police may initiate during the traffic stop, or if you're arrested, on the ride to jail. Never volunteer any information that can incriminate you. Usually your rights will be read to you either right after you're arrested or when you're taken to jail. If the police wait until you're at the jail before reading you your rights, that's fine. The only relevant factor as far as timing is the question of whether you were read your rights before any custodial interrogation. What do I do after my rights are read to me? There are generally four options that most people choose from after being read their rights. Do nothing, waive those rights and speak with the police, assert the right to remain silent, or assert the right to counsel. Asserting your rights must be unambiguous and specific. "I want an attorney," or "I don't want to answer any more questions," have been held unambiguous and specific enough to count as assertions.
"I want a lawyer right now."
"I don't know, maybe I should get a lawyer" is not unambiguous and specific. If you choose to do nothing, the Supreme Court has held that that constitutes neither a waiver of rights nor an assertion of rights, and the police can continue to question you. If you choose to waive your rights and speak to the police, anything you say can and will be used against you in a court of law. If you choose to assert your right and remain silent, the police must stop questioning you about that specific crime, but they can still ask you questions about different subjects. If you choose to assert your right to counsel, all questioning must cease until you're provided with an attorney or initiate questioning yourself. So what happens if my rights are not read to me? If the court finds that Miranda warnings were required and were not read to you, or were given incorrectly, the most common remedy is that any evidence obtained in the violation of Miranda is inadmissible in court. However, this remedy is not available for spontaneous statements. For example, if you were pulled over for speeding and spontaneously shouted, "The body's in the trunk,"
Okay, I confess, body's in the trunk.
that statement will be admissible as to any evidence gathered after the statement, such as the body being in the trunk. This remedy may also be unavailable for non-testimonial fruits of unwarranted confession. In other words, if you say something before being read your rights and it leads to the police finding evidence, that evidence will be admissible so long as the failure to read you your rights was not purposeful. Miranda is not the cure-all TV and movies make it out to be, but it is an important part of criminal procedure that the attorneys at LAWSMITH take note of when reviewing your case. If you feel your Miranda rights were violated, call us at 336-992-3600 today.